The judges are gracious enough to give you 2 minutes for the media, that immediately they get in, you'll have a minute or so to take your photos. Then thereafter, they will not allow more photos, together with any putting of a microphone here. So I think that is very clear. So in a few, the judges will be here. I wish you a very good day. I know it will be long, but it will be a good day. Thank you and God bless you. Photos.
Good morning, ladies and gentlemen. Welcome. This is a complicated Division E, 181, E to 11, E to 17, 219, 221, 227, 228, 232, 234, 237, and 254. My left is Justice Lawrence Mugambi. On my right is Justice Christine Nyoli, and I am David Majanja, presiding on this bench. Before we start, please switch off your mobile phones. But before you do, inform your beloved that we'll be here for quite some time, until probably 8 o'clock, because we intend to finish this matter today unavoidable.
My name is Shadrach Mose, the Solicitor General, appearing together with Mutinda, Charles Mutinda, for the first and second respondent, alongside with Professor Ketu Mugai, Senior Counsel, Kiragu Kimani, Senior Counsel, and Mahat Somane for the National Treasury and the Attorney General.
Thank you.
Thank you, my Lord.
I please my judges for the third and fourth respondents. My name is Gitonga Murugara. I do appear with Mr. Sheriff Sam Mwendwa and Mr. Josephat Kuyone for the third and fourth respondents, the National Assembly and the Speaker of the National Assembly.
If it may please me, my name is Milimani. I appear for the seventh interested party.
Petition A223, Peter Odhiambo Agoro.
So my name is Cecil appearing with Peter Wena and Eric Moore.
And
Eric Moore.
211 of 2023, Peter Odhiambo Agoro. Results should be given the judgment. Both amicai shall rely on the written submissions and briefs without necessity of making oral submissions. Those are our orders. So, we can now start. There was an issue of contempt.
Madam, maybe for information, you didn't mention the interested parties.
Yes. Sorry, I did mention all that.
We'll go by the declaration of the court. Thank you very much.
On that, to make their case, and the interested parties will support. So we are here until 1:30. We take a break in between. I realize I'm young, I'm getting older. So I don't sit as long as I need to. So we have until 1:30. We have estimated that each petitioner will take 15 minutes. We have all filed written submissions in great detail. In fact, the tracks of files have not been brought here because they will take up the whole space. Mr. Otiende Amono, Honorable Otiende Amono, what do you have to say?
Yes, many petitioners, and we all have our individual matters to prosecute. And now that we have been lumped together.
No, you have not been lumped together. All I have said is that I will hear each of you until 1:30. Each of you.
So I take the directions that each petitioner takes an average of 15 minutes,
Yes.
which is fine.
Yes.
Because some of the petitions we might actually consolidate the time. There's the question of the contempt application.
That one will wait. You will listen to it at 8 o'clock so that if people need to sleep. So let the contempt wait. It will not interfere with our work.
The good news, my lord, I was going to indicate to you, is that having consulted with the petitioners in E181, we intended to argue the contempt in the course of submissions, so that it's not argued separately. That would save everyone a lot of time, so that even in the response, as they're responding to the substantive matters, they'll respond to the contempt as well. That's what I've sought to persuade my colleagues in E181.
Yeah,
the court cases.
that is fine, but the contempt now, you see everybody sitting in the dog, we don't know where to put him. What is the alleged contempt? And he seated comfortably. Police, you get him a place to sit. But anyway, we'll proceed in that manner, but we'll deal with that issue. If you want to touch on it, but he has to defend himself anyway at the appropriate time. So he's seated here, we wait for his turn. Please inform your people to be ready just in case. Bring the pajamas if you have to. So we will start with Senator Mtata. 15 minutes, eh?
Yes.
At most. Don't repeat what I was saying.
We have consulted with the petitioners, and they have agreed that I go first on behalf of the third petitioner. And I wish...
And you know, that is one petition, eh?
Yes.
You know, this habit of, you file one petition, then you split each other. At least when I was taught by my teachers, what's it here? So one petition. And we were taught by the same teacher, one petition. And you take that 15 minutes, all of you.
Yes.
Yeah, we can't allow a situation where you file 30. You wanted to file 30, you file
81. On behalf of the third petitioner, I will also submit on E219 so that I consolidate the time.
Okay.
And it would have meant that I have 30 minutes, but I'll try and constrain all of it to 20 minutes. But the submissions, which are also
So you
unified.
introduce yourself because these are recorded with authorized notes.
My name is Otiende Amondo. I appear with Bryson Meto for the third petitioner in petition number 181 and for the petitioner in petition number 219. My Lord, the substratum of the petition and the submissions filed is that the Finance Act challenged here has various procedural and substantive instances of unconstitutionality. And cited instances of infractions of fundamental rights. My Lord, we will only highlight about 5 quickly because we submitted on most of them. Number 1, starting with the housing levy captured in Section 84 of the Act. It is our submission that this section purports to amend the Constitution. It purports to amend Schedule 4, Part 1, Part 2, Clause 8B, which exclusively gives the jurisdiction of housing to counties. The only leeway left for national government under Part 1, Clause 20 is housing policy. In purporting to create a levy and giving jurisdiction to the Cabinet Secretary to administer it, the Act is purporting to amend the Constitution, which cannot be allowed. And it's unconstitutional to that extent. The respondents seek to avoid that by saying that it's actually not a levy, it's a tax under Article 209. 1. My Lord, that does not answer the substantive issue of where the jurisdiction lies. By whatever name called, you cannot amend Schedule 4. In any event, my Lord, being taken to 209 can only serve the respondents adversely. For Article 209 is very clear on the kind of taxes that can be imposed. And it does not include such a tax as a housing levy or a housing tax. It is our further submission that it's unconstitutional to collect any form of tax, or in this case levy, without a foundational statute. Now, you'd have to establish, you'd have to create a statute, establish a housing fund, then you can collect such levies. That has not been done. I ask you, my Lord, to take judicial notice that in fact, having realized that anomaly, the respondents are only now trying to remedy that anomaly through a bill that is yet to be passed, the Statute Law Miscellaneous Amendment Bill 2022, which is yet to be considered by Parliament. My lords, you will note that at clause 83, they now seek to bring clauses that will bring definitions and a foundation for the levy. It is our further submission on that issue that that so-called housing levy is discriminatory insofar as it only targets formal employees and employers. That runs counter to Article 27. And to the extent that it is a mandatory contribution, it amounts to servitude and offends Article 30. Our last submission on that, my lord, is that they have sought to compound that illegality and unconstitutionality by requiring the Kenya Revenue Authority to be the collector of that levy. Under Section 5 of the KRA Act, Kenya Revenue Authority has no such authority unless introduced by legislation to collect this kind of tax. What they can collect is restricted. We invite, my lord, your ladies, to take note that this particular limb of the petition has not been answered by any of the respondents on the unconstitutionality of bringing a county function to national government. Our second limb, my lord, your lady, is that the Finance Act, now challenged, introduces 22 new provisions out of 84. 22 new provisions that were not considered at the first reading, not considered at the second reading, and were not subjected to public participation. This constitutes 25% of the entire act. Our simple submission on that respect, my lord, is that that scheme of things offends Article 201A of the Constitution that requires openness, accountability, and public participation. The respondents, especially the National Assembly, does not contradict that assertion. Their submission is that is a matter of the internal workings of the National Assembly, and the court should not interfere. Please submit, my lord, with respect, that there is a good reason why the Constitution, the statutes, and the standing orders require that these processes be undertaken. And public participation is not internal to the National Assembly. My lord, my lady, limb number 3 is that, my lord, before I leave that, the totality of the new provisions are captured in paragraph 64F of the amended petition. They are all outlined. My lord, the third submission is on the scope of the Finance Act. Our submission, my lord, is that this Finance Act 2023 includes matters that are outside the ambit of a finance act. And also outside of the ambit of a money bill under Article 114(1) and 3. Have had the courage to tell a sitting president in the BBI case that you are wrong. And I was on the other side of receiving that. But I'm happy that the court would have the courage to tell the chief executive and the executive general when they are wrong. So should it be when it comes to the National Assembly, when it comes to the Senate, and any other entity. My lords, my lady, as I close, we look forward to this court robustly examining the issues at hand without accepting the fear-mongering that you will hear from the respondents on the consequences of nullification of the act. Lord, we look forward to this new epoch where public-spirited individuals are complimented, not vilified. We submit, my Lord, that once you retire to examine the totality of our submission, we invite you to find the whole of the Finance Act 2023 as null and void. In the unlikely event, my Lord, that you find it necessary not to avoid the whole of the Act, we still invite you to nullify all those parts of the Act that are clearly unconstitutional and an infringement of fundamental rights. My Lord, I have exceeded my promised time by 2 minutes only. Thank you. Lord, I think I can create space so that because I realize there's limited resources.
It is very clear in my lords and lady. Article 109 of the Constitution, which is very prescriptive, states how legislative powers should be exercised by the National Assembly and the Senate. And it's very clear, my lords, that there are laws that will only be enacted by the National Assembly. My Lord, I want to read for the court the provisions of Article 109(3), which says that a bill not concerning county government is considered only in the National Assembly. So any bill that is not concerning county government, that legislative authority is conferred on the National Assembly. What then is a bill concerning county government? That answer is provided for in Article 110 of the Constitution. And Article 110 states that in this Constitution, a bill concerning county government means a bill containing provisions affecting the functions and the powers of county governments. Already, the bill, the impugned finance bill that is before this House, it's not in dispute that it amended Section 31 of the Employment Act, and it created housing levy or housing tax that's supposed to be deducted by Kenyans and passed over to county government for purposes of constructing houses. The question is then, my lord, is housing a function of the national government, or is it a function of the county government? My lady and my lords, that section was to exercise powers that are reserved by the High Court as created under Article 165. There will be chaos, my lord. Because Article 162 that creates system of courts has created limited powers to be exercised by judges of employment and the environment court. And it says Parliament shall establish courts with status of the High Court to hear and determine disputes relating to employment and labor relations and then environment. Then once
it means both houses. If it means one of the houses, it uses the name of the particular chamber. Under Article 249 clause 3, it states that Parliament shall allocate adequate funds to the Chapter 15 entities. So it's my submission that since the estimates submitted under Article 221 contain estimates of expenditure of the Chapter 15 entities, it naturally follows that the procedure under Article 221 must be read with Article 249 clause 3, and that would ensure that as per constitutional edict, the budget must be considered by both houses. In my submissions, I've also shown that after there were no estimates of revenue that agreed with Article 221 clause 2B that were submitted to the National Assembly. The document that are referring to as the estimates, it was not in the prescribed form under Section 38 of the Public Finance Management Act. So, I've submitted that the failure to involve the Senate in the consideration of the budget estimates and the Appropriation Act violated Article 249 clause 3, and that voided the entire budget making process, not just the finance bill. The estimates, the Appropriation Act, and anything that was done under the budget process in the 2023-2024 budget cycle in Parliament. It's also important to note that Article 96, 1 and 2 are very clear. And 91, the word is not promote. The Senate is there to protect. So the question should be, why protect? And the only time the word protect is used in the Constitution is in that particular clause. Even in clause 3, it's not as much. It's also used, but does not have the same connotation. To protect devolution. So we must look at the objects of devolution, including the equitable development of the country, and take into mind that the budget is executed in counties, and it falls upon the Senate under Article 201 and Article 174G to ensure that there's equitable development of this country. So that the national budget is not just done, and then maybe all the resources are taken to one side of the country. That would defeat the objects of devolution. And that one would require the involvement of the Senate totally in the making of the budget. Because, my lords, as you know, that the government basically has one policy document. If it's not in the budget, it doesn't exist. So there's no way that the Senate can be a bystander in the budget making process if the objects of devolution are taken into account. To enact the estimates of revenue, I'm assuming that they were introduced in Parliament. Yes, they have argued that they introduced the estimates of revenue in Parliament, but then they disappear. Even the report, which is titled Report of the Committee on the Estimates of Revenue and whatever, do not have any word on the revenues. It only deals with expenditure. So, my lords, the question that comes to mind is, where did the revenues of estimates go? And under Article 1, Article 9, 109+1, Parliament exercises its legislative authority through bills approved by Parliament and assented to by the President. We cannot introduce budget estimates through reports of Parliament. That's not how Parliament works. We do a lot of work in Parliament, reports, statements, motions, but Article 109 says the legislative authority of Parliament must start as a bill. And there is no bill that contains estimates of revenue that has been produced in this court. Further, my lords and my lady, I say that the failure then to enact those estimates of revenue into law means that this budget has got no revenue provision. And therefore, why do you need a finance bill? What will it be? Mechanism of raising which revenue? Raising revenue that has not been approved by Parliament? My lords, I also go, and under still under 121, clause 6. There's an interesting design in clause 6, whereby the drafters say that the estimates of expenditure of the national government, of the judiciary, and of Parliament shall be included in the Appropriations Act. It does not say they will form the Appropriations Act. What is to be included is to be added on to something else. And so the argument that the Appropriation Act only carries estimates of expenditure of the national government, of the judiciary, and of Parliament is not acceptable under Article 6. They are included in something else. But if you look at the Appropriation Act of 2023, it only has estimates of expenditure presented to the National Assembly, as published by the National Assembly, was a bill concerning county governments that ought to have been taken to the Senate, but was not, and that voids the finance bill ab initio in its entirety. Also, the fact that it is anchored onto provisions, onto the budget estimates and the Appropriation Act, which themselves violated the Constitution, then it's also void ab initio. So, my lords, with those few remarks,
Court. No matter, my name is Leuri. I will address the report for about 5 minutes and then connect another 5 minutes to my colleague, Mr. Laloma. Now, the petition by the Law Society has challenged Section 7 and Section 84 of the Finance Act. I adopt the submissions that have been made with regards to the housing fund. And my Lord, I just want to add that in terms of the constitutional test of purpose and effect, as set out in Article 201 of the Constitution, we submit that that amendment fails to meet the constitutional threshold. The fact that, Lord, Section 84 amends the Employment Act, and the preamble to the Employment Act defines it as an act that seeks to define the basic conditions of employment and related purposes. My Lord, we also have in our laws the Housing Act, which at Section 6 establishes the Housing Fund, supposed to be controlled by the National Housing Corporation. And my Lord, to that effect, we submit that the enjoin the submissions that have been made, the lack of a framework law to anchor those changes that were introduced and the amendments done to the Employment Act are therefore violate the constitutional test with purpose and effect and brings to full uncertainty within the law. But already, it is not even clear who is eligible to benefit from the scheme in the absence of a framework law. And that goes to also the impropriety of the public notice appointing the Kenya Revenue Authority as the body to administer the housing levy. Hello. There is also the question of whether the Act would find that Section 84 of the Finance Act violates the Constitution for the reasons that we have stated and the reasons that we have stated in our submissions, and to proceed to declare that section as a constitutional void and with no effect on the law, to consequently order that any funds that have been collected would be refunded. Lord, I cede the floor to Vice Minister.
My Lord and my Lady, the respondents hide behind the standing orders 133 to allege that it allows them to introduce amendments at any stage of the legislative process. My Lord, my Lady, they further state that the introductions were in fact products of public participation. And on the basis of these two arguments, they claim the same to be constitutional. My Lady, that proposition is both factually and legally unfounded and mistaken. First, my Lady, on the basis of fact, it is the respondent's submission that there was proposals by Sanabil, Kenya Wines Agencies Limited, and Tatu City Limited, as well as KPMG, that resulted in the introductions of these new provisions. In fact, from the report of the committee, it is only Kenya Wines Agencies Limited whose proposal was received and amendments to that effect accepted. My Lord, my Lady, even just this argument in itself reveals a problematic issue of partiality. My Lord, some proposals by the stakeholders were rejected by the Finance Committee for want of public participation, for the very reason that they were being introduced at that stage. My Lord, I refer you to page 86 of the report of the Departmental Committee on the Finance and National Planning, where they rejected KPMG's proposal on the basis of the stage at which it was being introduced. Yet, the other provisions that were introduced at the very same stage, they seem to now hide behind and say that they came from the public. My Lord, secondly, to demonstrate that they are legally unfounded, that position is legally unfounded, to propose that the Standing Order 133 overrides constitutional and statutory dictates.
Otiende Amolo left, and he equated this court to the bastion and bulwark of constitutionalism in this country. Quickly, in terms of comparative constitutional law, the year is 1919, August 11th specifically, whereby the Weimar Republic ushers a new constitution after the fall of Germany. that constitution is important for this reason. It had a Bill of Rights, and it properly recognized the individual as the locus of authority, just like our Constitution 2010. That Constitution had a shelf life of 3 years. It failed. Why did that Constitution fail? For these reasons. One, it was deliberately undermined by legislation under it. Two, it was deliberately undermined by political action. Your Ladyship, Your Lordship, you are the bulwark, the bastion of constitutionalism. And we have submitted to you our authority number 1, page 1 to 72 of our bundle of authorities, that legality, the principle of legality, is one of the tools that the judiciary uses to examine the acts of state. Your Lordship, Justice Mugambi, you asked a question on public participation. It has been flogged enough, but I want to give precise bullet point answers. Public participation is a principle enacted to address limitations of representative government.
The fourth respondent has attempted through an instrument which I would call a public declaration or a roadside declaration that gross pay is 1, 2, 3, 4 things. There is nowhere in the Income Tax Act that this has been properly defined. There is nowhere gross pay has been defined. In that case, the public finance management legislation states that there should be clarity, and the purpose is to collect as much as possible. We can tell the reason why the Finance Act put in the affordable housing is...
I appear for the petitioners in petition number 234 of 2023. In summary, my lords, my lady, the petitioners rely on the amended petition dated 10th August 2023 and the supporting affidavit of Dr. Charles Maguire the same day, as well as the written submissions and the list and bundle of authorities, all dated 5th September 2023. In the interest in that statute shall be the workers of this country, as I'll demonstrate shortly. There are two aspects that these petitioners focus on in their challenge of this legislation, and that is number one, that part of the Finance Act, that is section 26, that amended the Income Tax Act to increase certain individual income taxes. And number two, section 84 of that act, which amended the Employment Act at section 31B, so by introducing section 31B. Allow me, my lords and my lady, to begin by laying the constitutional basis of this challenge. I will start with Article 19, Clause 3B of the Constitution, which provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. That clause, paragraph C, which provides that those rights and fundamental freedoms are subject only to the limitations contemplated in this Constitution. Armed Forces Act, under the Prison Service Act, and the National Police Service Act, and that act, the Employment Act, does not apply to them. What Parliament does in the Finance Act is to bring them back to the Employment Act for the limited purpose of taxing them. It says we shall bring it, notwithstanding sections 3, 2, and we shall bring you back for the limited purpose of levying the housing levy on you. Then disapply the rest.